Hello, everyone. This is Michele Shuster from McMurray and Shuster, and I'm welcoming you to our annual, I think this is now an annual or a one-year anniversary, I should say, of our Thirsty for Thursday webinars that we started when COVID started. And I think these might become a tradition, Josh, that goes on well after COVID is way in our headlight, our rear lights, which hopefully is soon. So. But why don't you take a minute to introduce yourself?
Yeah, sure. I'm Josh Stevens, a partner here at McMurray and Shuster. And yeah, I can't believe it's been a year already. Just hard to believe.
And what a year. And the things that have happened in the year, not the least of which is the Facebook decision that was released 2 weeks ago. 2 weeks ago tomorrow, by the way. And this is a case that we've been watching with bated breath and anticipating an opinion for a long time now. And I can say that we are very pleased with the outcome of the Facebook decision. And so we're going to go into some details about that. Before we do, just a quick disclaimer. Obviously, we're not giving legal advice on this webinar. We would recommend that you see your own attorney if you have any questions about the implications of Facebook on your operations, or if you have pending litigation, that litigation. But we are happy to give you our thoughts, views, opinions. And hopefully that will give you some guidance on the types of things that are important to you and your operations that would be implicated by Facebook. So Josh, do you want to start with a brief recap?
Yeah, sure. So just to remind everyone, the way this case came up was through the Ninth Circuit that held what we refer to as the broad definition of an ATDS, that a system could be an ATDS if it simply stored numbers and dialed them. And you know that caught a lot of systems in its gamut. The Supreme Court, however, thankfully saw the light and sided with 3 circuits that had held that random or sequential number generators have to be used to store or have to be used to produce. But the key there is random number generators have to be used in one of those 2 functions.
Yeah. And we won't go into this. There are a lot of people that have been very interested in the semantics and the linguistics and sentence structure around the decision that around the Facebook decision and how the courts interpreted it, because I don't think that's really fundamentally what's important about this decision. You know, the factual background behind Facebook is interesting because I think it's something that we all encounter in contact centers, and that is in Facebook, or with Facebook, they have a auto notification function that notifies subscribers when a new login has happened on their account. And so the platform in Facebook wasn't a telephone, or it wasn't a telephone in the sense of picking up a phone and dialing and speaking to somebody. It was a texting platform. But as we all know, a texting platform is the same as a phone call under the TCPA. And Duguid got a number of these text messages on his cell phone, and he attempted to stop them, and he didn't, which is a story there for customer service. When you get these do not call, do not text requests, honor them, because unfortunately this is what can happen. And so what he did was he filed a case, and it was in the Ninth Circuit. I think it was in the Northern District of California, wasn't it, Josh?
I think that's right, but we can, you know.
Yeah, whatever.
It came out of California, which specific district?
Yeah. And so, but the important thing there was that Facebook was challenging this very broad definition of ATDS. Unfortunately, they lost. They appealed it to the Ninth Circuit. The Ninth Circuit agreed with the trial court, and that's how it ended up in the Supreme Court. You know, as part of the briefing that happened in the Supreme Court, Josh and I and Carl Koster, also from Noble Systems, were involved in the amicus briefing for the case. And it was a very thrilling thing to have the brief mentioned in the decision on page 10, and specifically pointing to some of the facts that we discussed about how the equipment that was used or how the equipment that was available back in 1991 when the TCPA was drafted. And Josh, do you want to talk a little bit about why that was important?
Yeah, so we have to go back in time a little bit to the late 80s and what generated the TCPA, which was a type of dialer that truly generated random numbers or generated sequential numbers. So each number was one integer up from the next number. And when the calls would go out to these numbers, they would hit cell phones, which, if you recall the giant bag phones from back in the day, minutes were very expensive, right? So they would hit cell phones, they would hit hospital networks, police stations, fire departments, right? All of these emergency services whose phone lines you really don't want tied up with telemarketing calls. And so that was the framework of the technology at the time. And so in the PACE briefing, what we tried to highlight was not only the technology of the time, but also that systems back then actually could use random or sequential number generators to store numbers, because this was something that in the Marks decision out of the Ninth Circuit, they had said, well, it doesn't make any sense to use a generator to store something, you use it to produce something. And so we pointed out some patents from the late 80s of technology that actually used those generators to store numbers. And that's what the court picked up on in its citation of the PACE brief.
Yeah, yeah, and we have to thank Carl Koster for finding that patent. He's on the board of PACE, and his partnership and the things that we do has always been so important. And so there's some issues that are specifically dealt with in the Facebook case, and the two that I think are interesting before we get to footnote 7 have to do with capacity and human intervention. The court addressed both of those. Those are issues we've been dealing with for a long time. When the FCC's 2015 order came out, they were really focusing on that term capacity and did not rule out that the future capacity of a system could also make it an ATDS, which led to some very strange arguments in courts about what systems could do if you added software, and that became an important fact for TCPA litigation, not actually the equipment you were using. And more than one client was very confused and upset about the approach there. In the ACA versus FCC case, which overturned that declaratory ruling, they pulled that back quite a lot because the concern was that if the definition was that broad, then anything, especially a cell phone, could be an ATDS, and then all cell phone users were potential federal law violators. I love that line from the case. But do you want to talk a little bit about capacity, Josh, and human intervention, and what the opinion had to say about that?
Yeah, so as you mentioned, the ACA, the FCC case, that was the one that really hemmed in that concept of capacity to a present capacity standard. The Second and Third Circuits afterwards, there's a line of cases in those two circuits re-emphasizing that when we talk about capacity, we're talking about what a system is capable of doing as it currently is configured. Or there's some language about if something is as easy as flipping a switch, you might include it. But if it takes more programming or additional hardware or anything like that, that's gonna be, definitely outside the scope. And the court here in this case repeatedly uses the phrasing of using a random or sequential number generator, right? It has the capacity to use. That's all very present tense language, and I think that they're implicitly saying you have to look at a present capacity standard. But what's kind of interesting on this is because of all of these capacity questions and then all the auto dialer questions and the broad Marks definition and all that, the focus for the last few years has really been on this issue of human intervention. And I know we've got a question in the registrations about this issue of human intervention. And by the way, if you have questions as we go along today, please do put them in the questions box, and we'll try to get to as many of those as we can. But this issue of human intervention, I think, has gone away now. If you look at footnote 6, the court says, and I just want to read it to be accurate, We decline to interpret the TCPA as requiring such a difficult line drawing exercise around how much automation is too much. So the court's really saying, we're going to look at this definition. We're going to look at this using a random or sequential number generator. That's going to be the focus. We're going to get out of this line drawing around, well, what if you click? What if you click twice? What if you dial 10 digits? We're not going to do that anymore.
Yeah, which kind of leads into the next interesting area of the opinion, and that's footnote 7. A lot has been said about footnote 7 in the last couple of weeks. Footnote 7 was actually specifically referring to the PACE brief. And as Josh explained, we provided a patent and a diagram of the system and how it functioned with the amicus brief that we filed. And so the Duguid's counsel was saying that if the word store really is not something that's important, then the word really shouldn't be there. And so it's got to have some type of meaning, and especially in the context of the randomly or store or produce telephone numbers to be dialed. And so the exact language was that, for instance, and they were talking about the patent, an auto dialer must use a random number generator to determine the order in which to pick phone numbers from a pre-produced list. It would then store those numbers to be dialed at a later time. And then they said, in any event, even if the storing and producing functions are often merged, Congress may have employed a belt and a suspenders approach. And so what we're seeing already from the plaintiff's bar, which has been very creative with its interpretations of ATDS throughout the history of the TCPA. So what we're seeing from the plaintiff's bar is they're saying that if you have numbers that have been sequentially produced and then dialed, that those are going to are going to lead to the conclusion that the dialer is an ATDS. But I think what they're really missing here is that, with modern dialing equipment today, what really happens if you have a list of numbers that are already produced that are being loaded to dialers, and then the dialers are dialing the telephone numbers. We don't really have those types of dialers that in and of themselves are randomly and sequentially generating telephone numbers and then storing them or producing them or storing them to be dialed later. So I think it's a really it would be a very difficult thing, I believe, in court for plaintiffs to argue that if those numbers in some way were just being stored in a sequential fashion as a result of the way that they're being indexed in various systems, that would turn the dialer that isn't doing that into an ATDS. I do think, though, that what is going to be very important moving forward, and it's something that we've always recommended, is that you have somebody take a look at your dialers, an expert take a look at your dialers, and you get an opinion from that expert and your counsel regarding what that system is doing as it's dialing telephone numbers. And you'll want it to conclude that it's not using a random or a sequential number generator to store and produce telephone numbers to be dialed. We have a case already that's out of Colorado. It's the Montanez versus Future Vision Brain Bank. And this is a case that there was a motion to dismiss pending. And what a motion to dismiss is that the court takes all of the facts that have been alleged in the plaintiff's complaint and assumes those to be true. And if based on those assumed to be true facts, there is no theory of law that would allow them to be successful in obtaining a judgment, then that case will be dismissed. But if based on just the four corners of the complaint, a legal argument can be made that they're entitled to judgment, then that case would not be dismissed. So the court was not considering facts in that case. It was looking strictly at the complaint and whether, if the facts as they were alleged, could somehow reach that conclusion. I think what the court was really saying is that, you have to have experts go back and look at the system and determine that it's not an ATDS as the Supreme Court has defined it. So, which is actually using a random and sequential number generator, and then and storing or producing those to be dialed. So anyway, I'm not quite as worried about that as some of the pundits are out there, but I will tell you that it is critically important that you be prepared as a company to address those issues. And again, the importance of that is making sure that you have a dialer opinion on what your dialer is capable of doing. So I don't know, Josh, do you have anything you want to add to that?
So I think that's the key point, right? Is being prepared to handle those complaints when they come in as quickly as possible, right? Having that dialer opinion in your back pocket, ready to go, because you don't want to have to expend resources getting an expert and going through all that jazz in the midst of litigation just to get the case kicked out because your system's not using a random or sequential number generator, right?
Yeah.
So doing some of that legwork ahead of time and being prepared for that is key. I think the other thing to keep in mind as businesses are moving forward here is this doesn't change a number of the other regulations that still exist, right? So the DNC rules are still there, right? The rules around the use of pre-recorded messages and artificial and synthetic voice systems are still there, right? Those have not gone away because of this ruling. And so businesses, it's a great relief, but they need to keep in mind that there are still these other frameworks that they need to pay attention to for their campaigns.
Yeah. Yeah. Something else that, we haven't talked about in a long time. I don't feel like I've given advice to clients on this in a long time, but that's abandoned call rates and what the requirements are if you're abandoning a call. If you start to use predictive dialers, then you need to make sure that you don't abandon more than 3% of those calls and that you have a recording that plays that discloses who called and that an agent wasn't available and gives the ability to do an interactive opt-out that would add that telephone number instantly to a do not call list. So, lots of additional things to consider. Also on the state front, there are a handful of states, and I think I've got the list here, Josh. You can correct me on this, all right? That have call to cell phone requirements that don't take into account whether an ATDS is used. And so you're still going to need to have consent for these types of calls if you are calling cell phones at all. And it's Arizona, Louisiana, New Jersey, Texas, Wyoming, Illinois, and New York. And I think that's the list. But obviously, that's something that you'll also want to check into if you're planning on dialing cell phones. Make sure you're complying with those state lists. So Josh, what do you think? Do you think we're going to see a whole bunch of plaintiffs, attorneys just decide they're going to dismiss all these cases that didn't have a random and sequential number generator that was being used to produce those telephone numbers and dial them?
Yeah, I don't think we'll see them dismiss them voluntarily, but I do think we will see a lot dismissed. I don't think it's going to immediately make all these go away. Like with the Colorado decision, right? We may see some court saying, well, we're going to allow some limited discovery. And then when we get to the end of that, then we'll decide whether to let this go. I think what we're going to see is a real shift in the plaintiff's bar's focus to the other areas of the TCPA that were not affected. And potentially to other areas of law. We've already seen FICRA cases, for example, ticking up over the last few years. We may see more of that, right? As companies or as the plaintiff's bar shifts its focus because these claims are just not quite as easy to do anymore. And the other thing we may see is the emergence of some state laws that could give the plaintiff's bar a hook in particular states. So, for example, we know there's a bill pending in New York that would create essentially an ATDS definition that's actually pretty onerous in New York. and it would have a private right of action. So you could see that happen where some states reopen the door that was closed by this decision.
Yeah, yeah. We've drafted an article that will be released on our website this afternoon, and it will talk about some of these things, recap what we're talking about here. But what I really wanted to do in that article was just urge, especially regulators and congressmen and women and state legislators to just kind of stop and take a breath, because the calling ecosystem, as they call it, is very different than it was when the TCPA was written. There are so many things that are out there now that are much better tools than the TCPA for eliminating robocalls. We have the Stir Shaken framework that will be implemented this summer. Stir Shaken will require that calls be authenticated, and authenticated both from the right to be able to use the caller ID that you're using, and that the telecommunications carrier, voice service provider knows who the company is or who the people are who are generating telephone calls. So just the ability to be able to trace back calls through Stir Shaken, and to be able to rely on an attestation level for placing calls is going to eliminate a lot of these robocalls. And Josh and I have been dealing with requests from the Industry Traceback Group, which was created by the Traced Act, and that has set up a consortium that's being run by the U.S. Telecom, which is the Carriers Trade Association, that traces back phone calls to their origins. And with the ability to do that, the FCC knows who's making telephone calls. Information is shared with the FCC, the FTC, the AGs, and they are looking at this information. And if there are calls that are being generated, and I think they've really been focusing on pre-recorded messages mostly, but if these calls are being generated that are problematic or, God forbid, fraudulent, then the FCC has shown recently that they're willing to take action on those and issue cease and desist orders, and to put out press releases that if a company isn't complying with the TCPA, TSR requirements, then they'll notify the carriers that that company is not trustworthy, which would be really the death blow for that company, because they wouldn't be able to carry traffic anymore. And so lots of different tools that are out there. And I think that as those go into effect here over the next couple of months, I think we're going to see a dramatic reduction in the unlawful telephone calls, and in even some of the unwanted telephone calls. Josh, do we have any questions that have come through yet?
So we have a few questions. These are that we received during the registration process, but again, if you have any questions, please do put them in the question box. And if we aren't able to get to them, we'll follow up with you afterwards. So Michele, I think one of the key questions here is, what effect is this going to have on the reassigned number database?
Interesting. That's funny. I was speaking to the company that is responsible for the reassigned number database, Somos, and asking them to come speak at our PACE Washington Summit, which hopefully they will be able to do. So the reassigned number database is a database of numbers that's provided by the carriers that obviously are for numbers that have been disconnected and reassigned. And so there's a safe harbor that's available if you scrub against that reassigned number database and call somebody who has received a reassigned number that wasn't revealed by that database. And so the purpose of that, it was initially very important, and that is for these calls that were potentially, because the definition was so broad in ATDS, that you would really want to scrub your numbers against the reassigned number database to take advantage of that safe harbor. So I think that there are maybe less uses than there were before, but I also think that that's going to be a very valuable thing for even text messaging, calling when you're using potentially pre-recorded messages or other types of calls like that. What do you think, Josh? I think there'll still be value in it.
Yeah, I think there's still value to it. And even if the value is a little less, I still think it's a valuable service, and also just from a customer experience standpoint, right? Just being able to kind of clean up your lists and just do things from, there's always the what do I legally have to do, and then the what's kind of nice to do just from a customer service and data hygiene
Yeah.
standpoint. And I think using that reassign number database, there's going to be value to that even from a customer service and data hygiene perspective.
Yeah, agreed.
Another question, the abandoned call safe harbor. You were just
It is
talking
a safe
about
harbor.
the percentages there. Are those going to stay the same, or are those changing as a result of this decision?
I have heard nothing about whether that would change. I think that I have heard some folks talk about if Congress chose to act to modify the TCPA, that maybe potentially looking at the abandoned call rate would be something worth discussing rather than making a complicated definition or an overbroad definition for ATDS again. But I haven't heard anything other than that.
Mm-hmm. Yeah, I haven't either. And this case didn't get to that, didn't touch that issue. So I think it's steady as she goes on the abandoned call issue for the moment. Are there any particular effects that this may have on specific industries, like the financial services industry or health? Anything unique based on the industry from this decision?
No, it's not really unique to any of the industries. I would say, though, something that is becoming somewhat unique to some of the industries and some of the calls that were previously exempted from the TCPA is that they're setting call limits. And so for those previously exempted calls from the TCPA, there's a three calls per month limit. We've got a blog, because we don't have much time here left, but we've got a blog on our website that addresses what types of calls that would encompass. Also, the CFPB's new debt collection rule has a limit of 7 calls per 7 days. So there are so many things that are going on out there right now that you have to keep up to date with. And then you had mentioned the FCRA adverse action type of issues for employers and in other situations. So lots of things that are impacting industries right now.
Yeah,
Just
absolutely.
not this definition.
Right. Well, Michele, it looks like we are coming up on time. Any final words of wisdom you'd like to give the group?
Yeah, I think it's really just so important for us to remain smart. I don't think folks should go out there and start cranking up their dialers. If that happens, then Congress is sure going to take a look at this and probably act in a way that would not be good for the industry, would not be good for business, charities, politicians, anybody. Having certainty around the way that you conduct business and that it's lawful, it's critical. It's just a fundamental premise. So I think if folks start moving quickly to try to react to this, especially legislatively, I think that will be a significant issue. For the businesses that are out there that are still scratching their head and saying, but Michele, I'm reading these things. They're still saying capacity is still an issue. Human interventions still an issue. And with footnote 7, every dialer is still an ATDS. I would again tell everybody to kind of take a deep breath here and consult with your attorneys, and they'll provide you good advice and make sure that you have a defendable position moving forward. But Josh, thank you. I think it's only fitting that you and I did the anniversary Thirsty for Knowledge Thursday. And as always, I always enjoy doing these with you. You've always got a great take that's very smart, and I know our clients appreciate that as well. So thank you.
Yeah. It's always great doing these with you as well, and we will continue these at least monthly, I think, from now until the sun sets on our careers. So
not going to happen, Josh. You're not ever retiring. All right. We'll talk to you all soon. Have a great day.